Welcome back for another episode of the Retirement Planning MadeEasy.com show. I am, as always, your host, Chris Hammond. And today I want to talk about how to get a little respect from your heirs. And this is based on an article that I came across a while back. Gosh, I think it was sometime last year, maybe it's like July or something like that. But I wanted to talk about an example. So you could kind of think of this as a cautionary tale. And the article was about Aretha Franklin and her estate planning, mistakes that were made and some of the, I guess, the fallout from that her family's experiencing now. But if you're watching on YouTube, you can see the screen here, and there's a link down here that shows where this article came from wealthmanagement.com. But if you're listening to the podcast and you can't see this, you could go to wealthmanagement.com. It's a website that a lot of financial advisors read, and you could just type in lessons for advisors from Aretha Franklin's estate woes. So if you wanted to check out that article, it's there. But just kind of some excerpts from that to talk about some of the mistakes that were made. So she didn't actually have a typed will. So this is kind of crazy, but when she passed away, and I'm just going to read this directly from the article. It said originally many believed that Aretha Franklin died without a will. And so when that happens, that would mean her four sons, they would likely share assets evenly, because if you pass away without a will, like if you don't have your own will, whatever state you live in, they have a will for you. Okay, so they have rules in place for who inherits what, and a will is what's going to direct the probate court to decide how your assets are going to be divvied up. And if you don't have your own will, well, the state that you live in already has rules in place that will be by default, so to speak, your will. Okay. So they originally didn't think that she had her own will written up. And the article says that meant that her four sons would likely share her assets evenly after going through probate. But several months after her death, Franklin's family discovered not one, but two handwritten, barely legible wills at her Detroit home. One was written in 2010, and the other was written in 2014. The 2014 dated will was found in a notebook under couch cushions, and the 2010 one was found in a locked cabinet. This is totally not what you want to do, when you're looking at planning your estate. And planning your estate, I mean, it sounds like such a complicated thing, like I'm planning my estate, or all it's saying is that when you get down to the nuts and bolts of estate planning, what your goals is to find out, or to determine and to set in place how you want your wealth to be distributed, how so that it's the biggest blessing possible for whoever it goes to, right? That's really what this is. This involves having a will. This involves making sure your beneficiaries on your accounts are up to date, that it goes to the right places. This may even involve using things like revocable trust, and we'll get into that a bit as we go through this article. That's really what estate planning is. It also involves things like when you're getting a will drawn up, things like that. You might want to go ahead and talk to that attorney when you're at his or her office about having powers of attorney drafted up as well. So that if something happens to you, you get incapacitated, you can't make decisions on your own. You've already got it set in place where there's legal authority for somebody else to take care of those things for you, so that they're not having to go to a court trying to get what's called a conservatorship over you if you've been incapacitated, or if it's your spouse or whoever it is. And then you have to prove to the court that you should be the one in charge of their finances. Now, you can bypass all of that by having powers of attorney put in place and talking to a lawyer, an attorney who can draft that up if you're already there taking care of a will and any other things that you're doing. If you're setting up a revocable trust, for example, that's really what this is about. That's how you're going to get respect from your heirs. And of course, I'm playing off with the Aretha Franklin song, Respect, on that. So going on forward with the article, um, it goes on to say, and if you're watching YouTube, you can see the printout the excerpt that I've put from the article. It says Franklin was hesitant to consult with estate planners despite years of poor health. So she was a very private person apparently, but she had years where she was already in poor health and would be able to kind of see where things are going, right? And that it would be smart and wise to put things up. But sometimes, if you want to keep things private, that can prevent you from doing the estate planning. It goes on to say a revocable trust could have allowed her to circumvent the courts. So let me unpack that a little bit. A will is how you dictate, where you want your assets to go when you pass away, and it is instructions that the probate court will use. All right. So a will does not allow you to avoid probate. It's just essentially these are my instructions to give the probate court who's going to be my executor, who's getting what, all that kind of stuff. But there are things that actually the will is not in charge of. So if you have an account, like let's say you have a life insurance policy and it has a beneficiary on it, you pass away, that money goes to the beneficiary. That doesn't go through the courts, probate court. Let's say you have an IRA and you have, two beneficiaries, you have two kids and you each want them to get 50-50 on the IRA. When you pass away, that goes to them. Even if you wrote in your will that you want 100% of this IRA account to go to some charity or to another child or a grandchild or whatever, what will dictate where those funds go will be what's on those beneficiary forms for those accounts. So not everything's going to go through probate, but the things that do go through probate, the will is going to be the thing that directs the probate court on how you want these assets divvied up. And if you don't have a will, then the state you live in has one for you already, so to speak, and they're going to divvy up the assets that way, even if that's not what you wanted. Now, when they say a revocable trust could have allowed her to circumvent the courts, what a revocable trust is when you put the assets into that trust, and then when you pass away, the directions of the trust and who inherits and is entitled to the assets are dictated by what was in the trust. And it's not a public court issue at all because the trust owns those assets. And the trust, you've detailed out in it how you want those assets divvied up. You may have something written in there that says so-and-so gets this account or gets this much cash, but they can't get it until they reach age 22. It could be something like that. But it wouldn't be a probate issue and it wouldn't be public information. And there wouldn't be articles like this written about you, assuming you were famous like she is. Most of us aren't famous. We're not going to have articles written about us. But nevertheless, it would not be public. But it goes on to say, but since she didn't use that tool, her financial affairs are anything but private. And it goes on to say, and I even highlighted this, this is a really common thing, even for people that are very well off, that have money with famous people. So they even give these examples in here. Bob Marley, Prince. I remember, years ago when he passed away, writing an article that I'd read about Prince and commenting on that. Howard Hughes, Pablo Picasso, Jimi Hendrix. It even says, which I didn't know this, even Abraham Lincoln, who, by the way, was a lawyer in addition to being president, all died without wills and triggered years of family squabbling. So this is not as uncommon as you might think. Now, let's talk a little bit about what should have been done, and then you can think about how to apply this to your own life. So first of all, and I think this is the low-hanging fruit, having a typed will is kind of, foundational, bare bones. Have that, preferably prepared by an attorney, and then that's going to follow the requirements of whatever state that you reside in. So handwritten is not all states actually even recognize a handwritten will. So if you're in a state that doesn't recognize a handwritten will, then that's not going to work right out of the gate. Aretha Franklin up in Michigan, apparently they still do recognize that, but it's still not really the way you want to go. Preferably have it typed. And remember, the will is giving direction to the probate court for the assets that will pass through probate, which that's not everything. And if you have things inside a trust, those aren't going through, probate. Those are going to be dealt differently. But having a typed will is, first of all, do that. The next one is use a revocable trust when necessary. And so that means if you have other assets, a lot of people will put a home into a trust so that when they pass away, it'll, without having to go through probate and that the time that it takes for that, it will go to who they want it to go to. So that's another thing that you could do. That's something that Aretha Franklin could have done as well. And then the last one is to pull all this together, it's really important to get help from a qualified attorney, somebody that understands estate planning. Now, I'm not an attorney. I don't put together wills. I don't, draft up powers of attorneys, revocable trust and all that. But I do talk to my clients about this type of stuff a lot and the importance of it because when you're retiring and you have wealth built up and you're wanting to manage it for yourself, most people want to make sure that when they pass on, that the wealth that they've left behind is used in the way that they see fit. They don't want it to be squandered. They don't want it to be a curse on any beneficiaries. If somebody has somebody that's potentially like a child or an adult child that maybe is in trouble with the law or has a drug addiction or something like that, a lot of times they don't want that person to get all of those funds right away because that could really hurt them actually in the short term and the long term. So this is an important issue that I talk with clients about a lot, about having these things set up, even things like getting power of attorneys set up. But what you want to do ultimately is once you've figured out what you want or talk with an advisor to say like what's important, how you want things structured, and how you want those things structured as far as who gets what, if there's any stipulations on that, that's where it makes sense then to talk to an attorney that can actually draft it up and you say, I would like for this to happen. Can you make it legal? Can you make the documents where it reflects my wishes on that? Okay. That's where they come in to help you out with that kind of stuff. That's all I've got for you guys today. If you haven't taken care of that, be sure to take care of that. Figure out how you want your funds, your wealth to pass on to the next generation, all that good stuff. And if you are looking for some additional help with planning for your own retirement, and you're looking for some tools to help you with that, then feel free to head on over to my website, retirementplanningmadeeasy.com. You can download a free copy of our essential step-by-step retirement guide, which will help you on your journey to retirement as well. That's all I got for you today. I'll see you guys next week on the next episode.